Neither borrower nor lender be. Most people will be familiar with this phrase. You may not know that it came from Shakespeare's Hamlet, but you've probably heard the phrase before. This essentially means don't lend anybody money and don't borrow any money, at least not from a friend. But the full phrase is neither borrower nor lender be, for loan oft loses both itself and friend. And this is absolutely true, because I hear so many stories, in fact just another one this morning, so I hear at least 2 or 3 a week from people watching my channel, and essentially almost always when someone lends somebody money, they either don't get it back or they struggle to get it back, and they get into disagreements, they get upset, and there's a fallout. So not only you lose the money, but you lose the friendship as well. Hence the second part of that quote, for loan oft loses both itself and friend. But what do you really do if you are in this situation where you've lent somebody money and you need to get it back? Because you do sometimes want to take action to get this money back, even if you've lent it to a friend. You might have been through all of the process of, I'll give it you back tomorrow, I'll give it you back next week, I get paid at the end of the month, and so on and so forth. But if all that has failed, what steps can you take, and in what circumstances might it be possible to enforce the return of this money? Well, this ultimately depends on whether there was an agreement in the first place. Because in order to enforce the return of the money from someone else, you need to have proof that there was the intention to form legal relations in the first place. In other words, there must have been some firm agreement between you before money was exchanged or loaned to you. Think of it when you take out a credit card, a loan or a mortgage, you go through endless documents in great detail before signing on the line, either electronically, on paper, or even sometimes on the telephone. But all of this will be documented and reduced to writing, setting out how much you're borrowing, over what period of time, how you're going to repay it, in what installments, for how long, how many installments, what duration, what level of interest, and so on and so forth. The trouble when you loan money to or borrow money from a friend is that most of you won't get it in writing because it's the friend or it's a family member, and you strongly believe that they will just pay you back because they're a good friend or they're a good family member. But in our line of work, this is usually not the case. We usually see disagreements further down the line. Whether there's a fallout outside of the remit of the money, but the money loan suffers for it, or whether there is just a difficulty in repaying that money, and therefore that sort of falls out of kilter, and then that affects the friendship as well. But ultimately, what you would need as a bare minimum before any money was paid over is an agreement, ideally in writing or by way of text message exchange, that confirmed how much was being borrowed, over what period of time, there was an intention to pay it back, in what installments, and obviously for how long. Now, it need not attract any interest over and above what you offered them in the first place. Just like if you take out a credit agreement on 0% interest. That's perfectly fine, but you'll still be signing the documents to confirm that there was the intention to create legal relations in the first place. So if you are in the position where you have lent somebody money and you're struggling to get it back, I know there are lots of you out there. What you need to do as a bare minimum is go right back to the beginning and find, when did this conversation take place of, can you lend me X amount of money? Ideally, they would have said, can you lend me X amount of money for Y amount of time, and I will pay you back by then, or weekly, monthly, or whatever it is. If you can document all of this into a form of evidence, which you will back up with a witness statement, relying on those text messages or emails or exchange or whatever it was, then you might be in a position to go to court to get the court to force your friend to pay back the money. But of course, going back to the phrase from Shakespeare, loan oft loses both itself and friend. Even if you get a judgment against your friend or family member, they may not be able to pay it back, but almost certainly you're going to lose the friendship or even the family relations in the process. Many of us have done it, so don't feel bad. I've done this many, many years ago, and I bitterly regretted it. It took me 2 or 3 years to get back money that was supposed to be paid back If only I had the experience then that I have now as a businessman and a barrister, I would certainly not have lent that money. Regardless of the circumstances, the answer would be no. My only approach to these things now is if someone needs the money or they need something, if I'm in a position to give that thing or money, and I want to, but at the same time I know that I'm going to lose it, as in write it off, have the money, have the thing, that's it, finished, and I know that I'm not getting it back, that's the only time I'm prepared to enter that arrangement. Otherwise, it is my suggestion to you in the strongest of terms, do not enter these informal agreements with friends and family. Not only are they likely to be unenforceable if you can't back it up with evidence, but even if you can, you're likely to lose the friend or the family relations in the process. So I know we're all familiar with this phrase, but these are just my thoughts on it for you, so thank you for watching.